Civil Advocacy Assessment video of Hardware Surfacing Limited. Calling the case of Hardware Surface Limited against primemacadam Limited. Who is here before us? Good evening, my lord. Mr. Henderson for the pursuer. Has your lordship had a chance to look over the initial writ and the craves, also the pursuer's written 22 note? You've had a brief overview, okay. My lord, the case before you is called today as the pursuer is seeking payment for the omitted liquid sums from the defender for various contracts between the parties dating from June of 2018 to November 2018. The defenders sought to retain the payments pending a counterclaim, and they are looking to offset the principal sum against remedial works carried out due to one of the contracts on November 26. What we're asking you to do today, my lord, is grant decree for the sum of £39,600 in terms of the pursuer's first crave. If your lordship agrees with us today, we're also asking you to grant expenses for this debate hearing, and also to appoint the case to proof in respect of the rest of the balance of the total sum sued for by the pursuer, and to move the defender's counterclaim also to proof. My lord, the case is essentially about business dealings between the pursuer and the defender. The defender had on 12 occasions contracted with the pursuer to buy and deliver to various sites the supply of X amount of Closemac mixture, which the defender would use on road surfaces across a number of sites across Scotland. The first dealing was back in 18th of June 2018. If I can refer my lord to the production number 5 of process 1, you will see the first invoice of 45678. And this is for a sum of 36,000. Sorry, beg your pardon, my lord. 3,600. And this was for the supply ton of 95 tons of Closemac. And this was delivered to a site in Alloa on 18th of June. And if I can refer you to productions 5.2 of process, again you see that the defender ordered 95 tons of Closemac. This was ordered on the 19th of June and it was delivered again to Alloa on the 20th. If I can refer your lord to production 5.3 of process, again you can see that the defender ordered on the 17th of September the same amount, but this again to a site in Edinburgh, which was on the 18th of September 2018. From my lord, you can see that there's a number of invoices listed in the productions of the pursuer. This was a pattern of business dealings. The defender would email the pursuer that they would need X amount of this Closemac product, and the defender would name the site that they want it delivered to, and the pursuer would oblige. My lord, if you look at from productions 5 of 5 down to 5.7, these all relate to sites in Kirkcaldy, all separate contracts for the said same amounts as the production numbers 5.1 of process and 5.2 of process, all are for the same amount. And if we go to the rest, are all to sites in Kirkcaldy, other than production number 5.13 of process, which went to Bothwell. But they're all for the same sum, as I said, my lord, for the same sum amount and for the same quantity. They were just separate contracts on different occasions. The defender is not disputing any of the defects above, other than the relation to the 26th of November contract, which is production number 5.12 of process. This was to the site in Kirkcaldy. The defender claims that they had to rip up and replace due to defects in the product, and they're now withholding payment for that contract, for the whole contracted amount. The defender's position
And pleasing law can be summarised in really two arguments. The first, that they are entitled to offset their illiquid claim against our liquid claim. Replace their remedial works against the pursuer's contractual amount they are due. They're also claiming that they're entitled to retain the principal sum until determination of proof. My lord, neither is competent here. I will start with their plea to retention, and that they have no defence to retention. The right of retention arises where there is mutuality of contract. If I ever confer you to, my lord, to Erickson and Institutes of the Law of Scotland, edition 3, chapter 3, page 86, which is the first in the pursuer's list of authority, my lord. Here he describes retention as being applicable where the parties are in mutual contract, where the obligation on the parties are the cause of one another, and can demand performance from the other. The mutual obligations are regarded as condition. And also refer you to Glock and Ivan, Law of Rights and Securities, in 1897, page 307, which is number 2 of the list of authorities of the pursuer, my lord. He gives a similar definition. He defines retention as the right to resist a demand of payment or performance till some counter obligation is paid or performed. My lord, the position is there is no mutuality of contract here, and thus no right of retention. My lord, the agreement between the pursuer and the defender are neither connected nor counter of each other, but as part of what can be described as regular business transactions over a course of time. Is your lordship familiar with Bruel Limited v. Pizak? This is the citation number 2005 SLT 37, which is an out-of-court decision by Lord Drummond Young, which is number 3 of the list of authorities by the pursuer. You're vaguely familiar, okay, my lord. This case involved a construction continuum agreement between the defender and the pursuer of the case. The pursuer was providing construction under a separate contract for a third party. The defender was responsible for design, procurement, temporary testing of all the civil engineering works, whereas the pursuer was part of the responsibilities was for medical engineering work and among other things. The question was, could the defender withhold payment due to the defective work carried out by the pursuer? Now in this case, Lord Drummond Young, if I can refer you to paragraph 10 of the judgment, he highlighted the right to detention had 4 features, 2 of which, my lord, I think are relevant here. The first Lord Young Drummond refers to was the right or the obligation on the contracts are themselves must be interdependent or counterpart of each other. In other words, if one part of the obligation is undergone, it'll affect the right or rights or obligations as a whole. They bounce off each other. My lord, with the case at hand, the pursuer and the defender can only be described as a series of independent, regular business transactions over the course of a few months, where the defender would request that the pursuer would deliver the X amount of clause match to the defender at their chosen location. Each delivery or arrangement would have no bearing on the next arrangement that the parties may or may not have. If delivery was not performed in Alloa, it had no relation to the delivery in Edinburgh or the sites in Kirkcaldy or Bothwell. Parties were not obligated to deliver more than it was arranged in the correspondence with that particular delivery, and there was no going contract each delivery product was the end of that contract. They would deliver to Bothwell, that would be the end of the Bothwell contract. There was no further obligations. They were not dependent on each other, as the obligations of future delivery had not existed yet. If the defender wanted more product, he had to make essentially a new contract term each time, and which they did over the course of 12 times. My lord, I refer you to the list of authority, paragraph 36 of the judgment of Inverson Private Limited Company v. Tercel Russell, Papermakers Limited. This has got the citation number 2010 UK Supreme Court 19. Now this is list of authority number 3, I believe, my lord. Yes, list of pursuers, list of authorities. In this, at paragraph 19, Lord Hope makes the point that the retention of contract, although a contract may not be in a single document due to the nature of businesses, it can still give rise to attention. You know, a series of contracts, I should say, my lord, can give rise to attention, even though it's not in a single document. He made the point that the critical question was whether the obligation founded on can truly be found counterparts of each other, to say they are really part of the same transaction, even though they're not in a single document. My lord, for the above reasons, it cannot be said that the obligations between the pursuers here and the defender are all part of the same transaction. The retention must not rise, and the defendant's pleadings are irrelevant. I refer you back to the Lord Drummond's features when he talks about the second feature, that retention arises where there has been a material breach in a contract. The defender has within their answers to condescendence 2, if I can refer you to the initial writ, my lord, admitted that the pursuer had been in breach to the contract of road supply to the Kirkcaldy site, beg your pardon, my lord, which are listed as process 5, number 2 of the list of productions, my lord, which is invoice number 56543, dated, as I said, 26th of November 2018, my lord. 2018, my lord, yes. They accepted this as being fact. If we accept this as fact, that there were a material breach here, it would only give the defender a right to retain the sum payment due at the pursuer at this site. Essentially, this means that they can only withhold £3,600. The defender had the material benefit of all the other deliveries, and the breach is irrelevant to the other arrangements where the defender had accepted the sum due. In other words, there was no material breach to 11 out of 12 of the contract arrangements. And if we accept what the defender is saying is true, they only can retain that said amount of £3,600. My lord, I move on to the defender's second pleading, that they may have a right to the doctrine of compensation or offset. The defender is looking to offset his remedial recovery of having to carry out extra works to fix the pursuer's alleged defective product on the road, which was totaling £96,000, against the omitted sum payable to the pursuer, which was carried out. In other words, he is looking to offset an illiquid claim, i.e. a sum that's not due to him yet, against the pursuer's liquid claim, which is ready and is payable to the defender. The pursuer, beg your pardon, my lord. This, of course, is against the general rule, that is, that the order for the defender to be able to have the right to offset debts, they must be ones of liquid. They must be one of the same. You can't offset any liquid claim against a liquid claim. And 2, it needs to be instantly variable by writ or oath and free pled before judgment. The issues with the first one. What the defender has is only a potential claim to payment for the alleged breach of delivery, and to the contract which is a matter for proof, my lord, not a matter, is without the scope of this hearing. He only has a potential claim to damages that needs to be established before he can offset any potential sum due to him. Of course, my lord, there is exceptions to this general rule, where you can set off an illiquid claim against a liquid claim, but my lord, none of them are applicable here. The first of the exceptions is where the defender has admitted liability. The pursuer within his answers has not admitted any liability, and is asking for proof. The other exception is where the parties are in bankruptcy. Here, the parties are insolvent. And the third leg is where justice requires it, that the courts have, an equitable discretion to allow an offset. In relation to the third exception, there is no justification for the court to use their equitable discretion. The proof is needed to see if there's been a material breach, and the pursuer to the defendant's averment performed all of the obligations in relation to the 11 out of 12 of the contracts. So, my lord, I ask you again to grant decree of the sum of £39,600 for the firm's first initial crave. I ask you to grant expenses of today's hearing in favour of the pursuer, and remove the remaining principal sum to defender's current claim to proof. I also would like you to procure a judgment that the defender's defences are lacking in specification. And I thank you, my lord, for listening to my submissions.